Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Today we are going to discuss case law on the medical negligence as well as the Consumer Protection Act. Right? So actually this decision came in year 2021 by the Honorable Supreme Court of India. The heading is like this: non-availability of the operation theatres does not come under medical negligence. No doubt, the doctors wanted to conduct the operation, but the operation theatres are not available in the hospital. So it will not come under medical negligence. This was stated by Honorable Justices Hemant Gupta and V. Ram Subramaniam in the case of Bombay Hospital and Research Institute Research Center versus Asha Jaiswal and Co. in Civil Appeal number 1658 by 2010 1658 by 2010, decided on 30/11/2021. So last year case, but anyway, it is a typical case where you have to apply your mind and then come to your decision. Normally, in the case of Indian Medical Association versus VP Shanta and others 1995, we came to know that medical service is also coming under the Consumer Protection Act. If there is any negligence on the part of the medical officer, yes, definitely you can file a case against him under the Consumer Protection Act, as stated in that case, as well as Jacob Mathew versus State of Punjab, and you know the Bolam test, all these things, PS Dhanaka case versus NIMS Hospital, all these cases you know. There, the negligence of the doctors is there. Here, the only single point is that the doctors wanted to conduct the operation, but the theatre is not available. This is the main point. Right. Now coming to the facts of the case. Actually, the patient, Asha Jaiswal and Co. is the wife of Dinesh Jaiswal, and he is no more now. She and her children, they filed a case against the Bombay Hospital for dereliction of duty or negligence or deficiency of service, things like that. Actually, he was a heart patient. Already angiogram was taken, a stent was inserted, but still it is not. He did not recoup properly. Now coming to the facts of the case, on 24/4/1998, at about 4 a.m., he developed complications in the hospital after the first surgery, and the pulse became very, very feeble. The pulse became very so the oxygen levels are going down, and the temperature is low, and the lower limbs, particularly the legs, they have gone cold. This happened at about 4 a.m. Immediately, the duty nurse alerted the doctor. She just made a call to the doctor. At the time, the cell phone was there. So she called the doctor on JTM Mobile. At the time, Airtel was called as JTM Mobile, and the doctor did not turn up till 9:30 a.m. Right, the doctor as usual came at 9:30 a.m. on 24th, and he has seen the condition of the patient, and he wanted to take the test, some the so-called diagnosis they wanted. Yes, immediately. So they have done the angiogram. Angiogram said that still one more nerve or some valve is blocked. So therefore, better to go for the second surgery to clear that valve also. So they have decided ultimately. So they took him by evening. He was taken to the theatre, but to his bad luck, there were Bombay Research. There were 4 operation theatres. All the 4 were busy. Some operations are being conducted. By the time this man was taken, so it was very much delayed. The operation, even though it was done, it could not be successful. Ultimately, after 2 months, he died. Now, the children and wife, they filed a case in the consumer fora regarding the medical negligence on the part of the doctors, right? So the defense also you have to know. The hospital contended that the patient was in the care of the qualified doctors. They have given the names also, and they say that no stone was left unturned to treat the complications. Daily dialysis and dressing of wounds was also done, but he died on 16/12/6/1998 because of the non-availability of the operation theatres. Had the operation been done on the particular time, there were chances of his recoupment or recovery, but since the operation was delayed due to the non-availability of the operation theatres, that could not be done. Now, of course, the up to the level of National Commission, they have actually cited, they have awarded compensation to a tune of 15 lakhs or so, because there was deficiency of service. When there is an urgency and there is an emergency, the operation theatre should have been opened, and that man, the previous operation should have conducted early, but it is not possible. An operation for everybody, operation is an important aspect. So anyway, the NCDRC found negligence right from the state, right from the district commission. They have found negligence on the part of the state and on the part of the hospital, and they awarded 14 lakhs 18,491. But when the matter came to the Supreme Court, yes, incidentally, by the time this matter is appealed, a decision is taken, an amount of 5 lakhs was paid by the Bombay hospital. But anyway, the Supreme Court held that it cannot be taken as a negligence, because the paucity or the non-availability operation theatres, it cannot be taken as negligence. Since already 5 lakhs was paid, let them take it as ex gratia, and no more money need to be paid to the relatives of the deceased. Good judgment. Please read it and enrich your legal knowledge. Thank you very much.